Professor Ajimendia and also Dr. Sasanti, you stay with me because surely you may have heard or known that President Mahama, in an unprecedented development, has removed the Chief Justice Isaba Torkornoo from office following recommendations from the committee set up to investigate acts of misdemeanor. And I'm just going to read to you that statement that was signed by Minister for Government Communication, Felix Kwachufusu. It says that President Dramani Mahama has, in accordance with Article 146 clause 9 of the 1992 Constitution, removed the Chief Justice, Lady Chief Justice Gertrude Iraba Isaba Saki Torkornoo, from office with immediate effect. Now, this follows receipt of the report of the committee constituted under Article 146 clause 6 to inquire into a petition submitted by a Ghanaian citizen, Mr. Daniel Ofori. After considering the petition and the evidence, the committee found that the grounds of stated misbehavior under Article 146 clause 1 had been established and recommended her removal from office under Article 146 clause 9. The president is required to act in accordance with the committee's recommendation. Prof, surely you have heard this, you've seen this, and you have followed this. What are your initial comments?
Well, I'm not surprised at all at the decision of the president to remove the Chief Justice, because I think this is something the party and himself wanted, and they got it. Because if you look at the party, the NDC, during the campaign, it was stated publicly, not only by the flag bearer, who is now the president, but also by some stalwarts of the party, that when they come to power, the Chief Justice will be removed. It was stated clearly. And that reminds me of the same situation when the NPP was in opposition. And they, including Akufo-Addo, who was the flag bearer, and some of his stalwarts, also indicated that when they come to power, they will remove the chairperson of the Electoral Commission. And I'm citing this to create a context for me for how dangerously we are treading in terms of how our independent institutions ought to be protected in order to have trust. We don't have to politicize certain key institutions of governance so that people can continuously have trust and believe in the role that they play in a democracy. So, towards the elections, actually, there was a program at the, I think, Kempinski, sponsored by IDEC, and I happened to be a speaker there. I think Cardinal Texan was there and all. And I made a point then, before even the elections, that President Akufo-Addo has made a very dangerous, he has set a dangerous precedent by removing Charlotte Osei. And I still stand by that statement that I made. And that is what seems to have opened this gateway for chief political actors to begin to work the way they are working with independent institutions. In fact, yesterday we were told that the NDC has not finished yet in terms of people that they intend to remove. And I guess it will be the electoral commissioners, and even I think a petition has already been sent to the president. So my main concern here is not necessarily what has happened to the former Chief Justice, but my concern is more with the institutions that we must protect in order to ensure, effective administration of our democratic system. And the Chief Justice and her court, again, during the rule of NPP, you recall the then Minister for National Security, Kandapa, making a point that, look, if the court continuously rule in favor of one side, that will be a threat to security. I hope you recall that statement. that Kandapar made. You see, I'm citing all this to really create a context for this, because I think if we are not careful, we are driving ourselves needlessly to a situation where the respect for our democratic system can be seriously upended, undermined, if I should say. Okay, so my reaction, as I say, certainly for me, I wasn't surprised, because they stated it clearly before the election that they would do that, and they've done it. But I'm looking at the repercussions, how this really affects the balance of power amongst the three key institutions of governance: the executive, the legislature, the judiciary, and the independence that they are supposed to have in order to ensure effective checks and balances. And for me, if the executive decides to attack one, then there's a danger there. I'm not saying that if a Chief Justice runs amok, he should just be allowed to stay on. There are rules for that. But if you look at the petitions and all, I think it seems to be setting a very low threshold. Even though I've heard another very brilliant public commentator saying that, in fact, low threshold of accountability is good for democracy. Yes, but not when it comes to such important institutions. So I guess my point, and I'm sure we're going to continue the discussions further, is that my initial point is that I wasn't surprised at all. It was engineered, just like Akufo-Addo got somebody to send a petition. As we speak, I don't know even what that somebody is. And he claimed then that he's just a conveyor belt. Akufo-Addo said it publicly. I'm just a conveyor. I don't want my president to become a conveyor belt. I want my president who thinks and decides far beyond what he's confronted with in terms of the securing the long-term stability and progress of the country. So I don't want people to say, yesterday I had a very respectable legal educator using the same argument that Akufo-Addo used, that I and many others condemn, that you cannot say you're a conveyor belt. And that person used the same argument that Mahama is just a conveyor belt. Of course, he went rightly on the constitutional path. Nobody can fault the president. He followed exactly as the rule says in the Constitution. So he hasn't done wrong on that. But as I say, I don't want people to think that my president should be simply a conveyor belt, but not someone who looks beyond.
Well, Prof, then let me stay with you on this. It would have my initial question would have been that, but for the comments the president made and some of his political members made before the election, you would say that procedurally he has not done anything wrong. This is what I hear you say.
Correct.
Okay.
Correct.
Okay.
Because that's exactly the same thing Akufo-Addo said.
Okay. So what is the challenge? And is it the implementer of the law, or there's something fundamentally wrong with the law or the procedure as outlined in Article 146, especially because former Chief Justice Sophia Akufo as well has said that it's particularly not who is sitting at the position, but she finds something fundamentally wrong with the processes that are outlined in Article 146. What's wrong? The person who says is a conveyor belt, or the law that made him the conveyor?
I really will go straight to the system that allows this kind of thing to happen. And I think a few days ago, another respectable public commentator has repeated what I have written and published, because when this case started, I put something out there on the platforms and all, simply saying that the system of selecting or appointing our president must be reviewed. It should be taken away from the executive. The president should not be appointing chief justices, especially if we are arguing on the basis of the balance of power. And my fear in this country is that we are not careful. And by the way, yesterday also, I heard some MPP stalwarts also saying, look, when we come to power, the chief justice will be sacked. Look at this. And look, we got to be serious with ourselves. You see, that's really, I'm concerned about this. So we can decide, especially since we have already ongoing process to review the Constitution, we must think seriously about reviewing this aspect to take away from the executive the appointing of chief justices. And if we want a good example, go to Kenya, not Europe or America. Go to Kenya and see how they elect or select their chief justices. They have insulated the whole process away from the executive, precisely because of the issues I'm raising and the challenges that we are facing. Okay. We don't want that. So there are ways to do it.
Dr. Asante, I'll come to you shortly, but permit me, I'll stay with Prof a little longer. Prof, so one of the arguments as well is that the bar that has been set for stated misconduct or misbehavior it's not too clear. And so what is stated misbehavior? But if you look at the findings that was presented to the president upon which he must act, is that, well, some of the expenditure were quite unlawful. Now, the Auditor General is the one that cites that these expenditures at the Judicial Service by her travels with her family and all, though they are also guided by the travel policy of the Judicial Service. They cite it as not a proper use of public funds. And I recall that her lawyer, former Attorney General Ayiko Otu, argues that why wouldn't she be surcharged instead of removed, because then the bar is low. But my question to you really is, if the Auditor General cites this as not a proper use of public funds and she's even surcharged, would that not be an admission to the fact that she has conducted herself wrong?
Well, earlier you said that perhaps the threshold is too low, and also the definition of misbehavior is also nebulous in the Constitution. It's true. Misbehavior, anything can be, because if it's a matter of expenditure, overspending, or misappropriating, whatever the term is, if the Auditor General was to go into the executive's expenditures, they will see perhaps bigger ones. That's the reality. Bigger ones. And I'm very happy what President Mahama has just done. You know, towards the UN General Assembly, he's made a statement that nobody should be going without approval. You know why? Because the practice has been at the executive level, sending hundreds of people to the UN during this General Assembly opinion, doing practically nothing. It's an opportunity for the civil servants to make extra money because they give them big per diems. I know that for a fact because I have friends who've been taking advantage of this. I mean, look, over expenditure or misappropriating state funds, then almost all public officials should be out of office. And I can say that. I know what goes on in government. You see. So anyway, sure. If the Chief Justice has been caught overspending or misappropriating or whatever, sure. But now I don't know whether this should have been a strong case enough. Maybe it is in terms of morality or ethics in government and law. We can use those arguments to justify that.
Okay.
There's a general problem in our country we need to fix. And I think President Mahama is gradually doing that, especially by his announcement stopping frivolous travels by public officials.
Okay.
You know? So for me, it's not here, neither here nor there.
Dr. Asante, I'll let you come in now. Is this rule of law or just bad precedent?
I think I'll commend Prof for setting the foundation for this conversation. He made reference to the threats that political actors, our leaders, have, issued to us. When I come to office, I'll do this. And they come and they execute exactly that. He has done so well. So let me build from where he left off. I will look at let me answer your question and move straight away into other things. Is it what? Rule of law or what?
Bad precedent.
It is rule of law. I am not a lawyer, but my understanding of rule of law is that it is, a practice which has two components: equality before the law and due process. The equal subjection of all men and women to a law is one component, and that nobody is seen to be above the law. And the other bit of it is that any decision you take must reflect the laws of the land. On that score, you realize that let us judge how the whole process went through relative to the dictates of Article 146, that there must be what? A prima facie case. There was. There must be, Council of State looking at that. There was. There must be a committee set and all that. They followed. And up to date, nobody has been able to fault the process. It tells you that what they went through was nothing but what? The process. You also recall that the right of the Chief Justice to challenge this process was also triggered as he went toward the Supreme Court on a number of occasions. Of course, did not win anything there. And he moved on to ECOWAS Parliament. That's part of the institutional processes he went through. It tells you that all in all, democracy was at work. The Constitution was working. All right. Now, the committee has finished its work, and the president comes in with the final requirement on his part to what? Deliver the committee's reports, which we have also seen that. If you put all in all, nobody can fault the president. Nobody can fault the process. The process has gone through as the Constitution dictates. But it brings us, if you look at it in general, and the problems that people have, some of which the Prof has also alluded to, the issue of the threshold. People argue that the threshold is so low and all that. And I ask myself that over the years, we have had governments that have come to office, change part of our laws, our rules of engagement, but they forgot about 146 and it continued to stay intact in our books. So the question is, permit me to use this expression of young people, now who calls them? They've seen this. One would have thought that they would take steps to deal with 146 and make it elaborate and, raise the bar so that it becomes a standard. Look at the president, the provision that touches on impeachment of the president. It's such a high bar that the framers of the Constitution made it so. What prevented us from following that example and strengthening 146? You recall that immediately this process was triggered, Ayariga, the majority leader, hinted of its government intention to look at this provision and then what? Do something about it. And I asked myself, why now? Now that we are seeing the effect, I was so surprised that all the political actors went to sleep and allow 146 to remain in our book with that low threshold. And now they have used that one to ask Charlotte Osei. They have used that one to also what? Get the Chief Justice away. Now people are complaining. And why do we complain when we knew that this very provision was problematic and they needed to what? Address that? Prof also reminded us about what Kandapa's statement that he made, which is very, very, very important. That this was a statement not coming from any other person, but the National Security Minister. We went to bed with this. And today, the cat is out of the bag, and we are here complaining. People will tell you that, look, it undermines the spirit and letter of democracy. I disagree with respect. Why? Look, democracy, there's no doubt, is driven by institutions. When you don't have institutions, democracy is gone and gone forever. But that doesn't mean that institutions are not allowed to work. And when we say institutions, what are we talking about? The rules, the regulations, the procedures, the norms. All right. If any human being in this country or particularly if you occupy public office, you owe it what? A duty to make sure that your conduct, your operations fall within the remit of what? The institution. Here, I'm talking about the rules of the game. If you go beyond it, obviously, whether the threshold is low or high, you'll be judged by it.
Right.
And that is the spirit behind democracy. Democracy is anchored on rule of law. And that within that democratic space, nobody is above the law. It will be used as a standard to measure your conduct. But that aside, we also talk about the issue of Prof was worried about issue of institutions, which I agree with him. Look, once you bastardize institutions that drive democracy, democracy grinds to a halt. And we should, over the years, if we pay attention to reports from the think tank, i.e. the CDD, warning us about what? Institutional breakdown and weakness, we have gone to sleep about all these reports because we got them free. CDD and Prof will tell you how much they spend in conducting survey and all that. But when these things are churned out, people do not make use of them because they have not spent money on that.
Right.
But they are useful information that we need to shape the contours of our governance to make it better. Okay. There are means of looking at how you want to appoint Chief Justice, and Prof also talk about the fact that we can look elsewhere, which I agree with him. All right, look at the Gambian experience, where they even select Chief Justice from people from outside their country. Right. Some Ghanaian judges have gone there to occupy the position of Chief Justice. Why are we caught up in this web? Also, the Electoral Commission. There is also the other examples where some countries appoint the electoral commissioner from outside the country. What about that? All right. We seems to always create a situation that puts us in a very tight corner. Right. And then we come back to complain. I don't see the complaint. The real complaint is that we allow Article 146 to stay all this while. And now we have our fingers bent. Well,
Prof, I'll let you have the final bite to this particular conversation. And it will be that really, you have mentioned that the constitutional review is ongoing. So it's an opportunity for us to look at some of the things that's in the Constitution, as we appreciate that the Constitution will mirror the aspirations of a people at a particular time. But is this to suggest that every time we review our Constitution, it has to be done frequently?
Not at all. I mean, Constitution is not somebody who has written an essay for my good Professor Dr. Asante to review and correct and replace. No, not at all. Constitution cannot be toyed with.
The one that people outlive it at a particular point, then we may have to ask for a review then. For example, after the review, after 30 years, we'll say that it doesn't mirror our aspirations, and so we have to sit
Precisely.
again.
After 30 years, 3 decades, I think that's about time. Especially we have experienced so many hiccups, we have experienced so many challenges and all. And that is the guide for the review that we are asking about. Because this conversation for us is very important. And there are so many other aspects of the Constitution that I believe the committee is looking at. So I think it's time. And I think there should be some kind of a unified support for this, especially the political parties. You see, it by themselves, no political party will review what benefits. And certainly this Constitution, because it concentrates power so much at the center, in one person, the president, they like it that way. Because if you win, you have everything for yourself. So I guess my point is that the review is just timely, and President Mahama really set it up. And I believe that his whole heart is behind them, and that whatever they propose, if it reflects the general sentiments of people, I'm sure the president will support it.
Right. Prof, thank you so much for spending your morning with us and getting into all of the issues. And Dr. Asante as well, thank you so much. You spent your yesterday plus your morning with us here on the show. Please stay with us. You're watching the AM show this morning.
The last time I dealt with the bailiff. Now, this bailiff later on apparently goes to my office.